3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the grooming process and tested what the records could actually prove without speculation. Today, we are examining Victim Testimonies Part 1 and testing what the records can prove. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is Virginia Giuffre's 2015 sworn deposition in the Southern District of New York, where she described being recruited from Mar-a-Lago at age 16.
And this deposition really is the cornerstone. It's a sworn legal document, not just a story.
Right. It's subject to cross-examination. It provides the framework.
So our mission today is to conduct a forensic audit of this testimony and also that of Courtney Wild.
We're separating what is a verified record from what's still just an allegation.
And we map those statements against the flight logs, against police affidavits, against any independent corroboration we can find.
The objective here is to cut through the noise, and look at the signal.
Just the signal. Verified record versus an allegation pending verification.
And precision is everything. We have to treat this 2015 Giuffre deposition as evidence.
Not as a memoir. It was filed in the Southern District of New York. That means perjury charges are on the table if it's false.
So looking at the timeline she establishes in that document, it begins in the year 2000. Virginia Giuffre is 16.
And the location is very specific.
She wasn't just someone they found on the street. She was an employee.
Correct. She was working as a spa attendant at Mar-a-Lago in Palm Beach.
And the record is clear about her role.
It is. She was in the locker room, managing towels, keeping things tidy, and that's a critical point.
It's the access point.
It's the access point. And the recruitment mechanism didn't start with Jeffrey Epstein.
No. The sworn testimony identifies the recruiter as Ghislaine Maxwell.
This is a pattern we see again and again in these files, but here it's laid out so explicitly. The entry point is the facilitator,
not the principal.
The deposition describes how she was approached. Maxwell comes into the spa. She doesn't lead with anything sexual.
It's professional.
It's professional, a compliment. She comments on Giuffre's appearance, her demeanor, and then comes the offer.
A job as a traveling masseuse for a wealthy businessman.
And the testimony details that transition from, a legitimate high-end setting like Mar-a-Lago to Epstein's property in Palm Beach.
This is the grooming phase, normalizing the environment.
It's a calibration process. The testimony is very clear about the escalation. It did not start with abuse on the first day.
That's consistent with the 2008 Jane Doe testimony we have.
Yeah.
It was standard operating procedure.
Giuffre describes a period of normalization, massages that were just massages. The environment was sophisticated, wealthy.
Disarming.
Completely disarming. And then they introduce this standard, the requirement for sexual acts to keep the job.
And the record shows that once that line was crossed, once the victim was compromised,
the geographic circuit began.
Let's focus on that term, the geographic circuit. Giuffre's testimony maps out a clear pattern of movement.
She lists Palm Beach, New York, New Mexico, the U.S. Virgin Islands, and London.
Now, anyone can claim they traveled. Do the records, specifically the flight logs, actually support this?
They do. This is where the forensic audit becomes the validator for the testimony.
So you can overlay her stated timeline from the deposition.
Right on top of the Epstein flight logs. And we can verify her presence on that plane by date and by destination.
Are there specific examples where she's listed?
Yes. For instance, her presence on flights to the U.S. Virgin Islands is corroborated by the manifests. She is listed by name.
So that moves her account from a claim of, I was there,
to a documented fact of, she was transported there.
And that transport is the federal crime. That's the Mann Act, trafficking across state lines.
And international lines. Which brings us to the named actors. This is where the 2015 deposition gets incredibly detailed.
And where corroboration gets more complex, she places herself in London in 2001.
This is one of the most heavily litigated parts of the entire file. Giuffre testified she was trafficked to London. She describes the whole itinerary.
Including a night out at a specific club?
The Tramp nightclub. And this is where Prince Andrew enters the record.
What does the testimony allege?
It alleges she was directed by Maxwell to have a sexual encounter with Prince Andrew. She describes the environment inside the club. dancing. She even notes a specific physiological detail.
That Prince Andrew was sweating profusely.
Yes. And then, after the club, they moved to a private residence.
Ghislaine Maxwell's home in London.
Correct. The testimony states they moved from the nightclub to Maxwell's home, and she alleges the sexual abuse happened there in an upstairs bathroom.
Testimony is one form of evidence. But is there anything physical? We have a photograph.
We do. The photograph showing Prince Andrew with his arm around Virginia Giuffre's waist, and Ghislaine Maxwell is in the background, sort of smiling.
And that photo was a central piece of evidence in the civil case. Giuffre v. Maxwell.
It was. Maxwell was grilled about it in her 2016 deposition. The photo's existence corroborates the physical proximity of these three individuals at that time.
It anchors the testimony in a physical reality.
Now, Prince Andrew has disputed its authenticity in the media. He's claimed it could be doctored, that he has no memory of the event.
But in the legal context, in the civil case.
In the context of the settlement, the photo remains part of the evidentiary record. There was no forensic analysis presented in court that successfully proved it was a forgery. It stands as a record of association.
We also have to examine the other high-profile names in that 2015 deposition. We have to discuss Alan Dershowitz.
And this is a very different category in the file because here we have directly conflicting sworn statements.
So in the 2015 affidavit against Dershowitz, what does Giuffre allege?
She alleges that she was directed to have sexual relations with him. She provides details about locations, the context of the encounters.
But Dershowitz didn't stay silent. He fought back immediately with his own records.
He did. He filed what's called a declaration to intervene in 2015. And he vehemently denied being at the places she described at the time she described.
He produced alibis.
He produced travel records, credit card receipts, phone logs, all in an attempt to prove he was somewhere else during those time windows. He has always maintained the testimony about him is a complete fabrication.
So if we're looking strictly at the documents, what's the conclusion?
From a forensic standpoint, we have a direct conflict of testimony. It's her sworn statement versus his sworn denial backed by his documentary alibis.
The record is not settled here.
No, it's not like a flight log placing someone on a plane. We have to report the conflict. Allegation versus documented alibi defense.
Okay, let's move to another name that appears repeatedly. Jean-Luc Brunel.
Brunel is pivotal. He helps us understand the pipeline. The files suggest he wasn't just a guest, he was a node in the network. A trafficker. That's what Giuffre's testimony describes him as. She alleges she was trafficked to modeling scouts and that Brunel was the key figure moving girls from Epstein's circle into the modeling world.
And vice versa.
And vice versa. This suggests the operation wasn't just contained to Epstein's properties.
It suggests a porous border between the trafficking ring and a legitimate industry, in this case fashion.
Right. Brunel's agency, MC2, becomes a point of interest in the files. The allegation is that the promise of a modeling career was used as leverage.
To procure victims.
And victims were used to service people who could provide that career. It's a cycle.
This brings us to the training regimen. This is one of the most disturbing parts of Giuffre's testimony. She wasn't just a victim. She says she was trained to be a recruiter herself.
This is the institutional behavior aspect. The records show Maxwell didn't just want victims, she wanted a system, a self-perpetuating one.
So Giuffre testified that Maxwell trained her. On what exactly?
On how to approach other young women. She was told what to say, how to make them comfortable, how to pivot the conversation from normal topics like school or shopping to the topic of massages.
A transfer of methodology.
It is. The 2008 testimony alludes to a quota system, a constant pressure to bring in new faces to keep the operation going.
And if the girls didn't recruit?
Their own standing, their financial support was threatened.
It's turning the victim into a tool of the victimization.
Precisely. And that leads us directly to our second block of evidence, Courtney Wild. Because Giuffre's was recruited from a high-end, exclusive spa.
But Wild's experience shows a different vector, a more local one.
Let's look at the Courtney Wild account. The source records here are the Courtney Wild Supreme Court petition and the Rep. Speyer Bipartisan Courtney Wild Crime Victims' Rights Reform Act.
How does her recruitment profile differ from Giuffre's?
First, she was younger. Courtney Wild was 14, and she wasn't found at a place like Mar-a-Lago.
She was recruited from the local community in Palm Beach.
Right. Her recruitment vector wasn't a job offer from a socialite. It was peer-to-peer.
This is the pyramid structure we mentioned.
Yes. Wild's testimony is critical for understanding the financial incentive structure. She describes a system where she would be paid for a massage, the cover for the sexual acts.
But she'd get an additional payment if she brought someone else in.
An additional payment. A finder's fee, essentially.
So the economics are straightforward. A certain amount for the act, but more for the referral.
The amounts varied, but the mechanism is what's important. It weaponized the girl's own social networks.
And for a 14-year-old in financial need.
The promise of easy money just by bringing a friend is a powerful, predatory lever. And this isn't just her testimony. This matches the Palm Beach Police Department's own findings on the recruitment cycle.
Courtney Wild is also central to the legal history of this case because of the CVRA violation. Could you explain what that is?
The Crime Victims' Rights Act. Courtney Wild became the public face of the legal fight over the 2008 non-prosecution agreement, the NPA.
The deal that gave Epstein federal immunity.
It did, but crucially, it also gave immunity to his potential co-conspirators.
And Wild's testimony, her lawsuit, it anchored the argument that the victims were completely kept in the dark about this deal.
That's it. The CVRA requires that victims be notified of plea deals, that they get a chance to be heard. The records prove the U.S. Attorney's Office in Miami deliberately hid the existence of this deal from Wild and the other victims.
They didn't find out until after it was signed and sealed.
Correct. So her testimony isn't just about the abuse she suffered. It's evidence of a government failure to follow its own laws.
And unlike the anonymous Jane does, Wild waived her anonymity.
Which is significant. It allows us to cross-reference her statements directly with public court filings involving the Department of Justice. Her credibility on the legal process is bolstered because her account aligns perfectly with internal DOJ emails and reports that came out years later.
Let's move to evidence block 3, documentation and corroboration. We've heard from Giuffre and Wild. Now we need to look at independent witnesses who can place people in the room. The key record here is the deposition of Johannes Sjoberg from May of 2016.
Sjoberg is a crucial corroborating witness. She was recruited into the circle, incidentally, by Virginia Giuffre, which confirms that recruitment chain we talked about.
But she often acts as more of an observer in the testimony.
Yes, and she describes a very specific incident involving a puppet. It sounds bizarre.
It does. But what does the record say?
In forensic terms, it's a flashbulb memory, a specific, unusual detail that's very hard to invent. Sjoberg testified she was at Epstein's mansion in New York.
And who was present?
Jeffrey Epstein, Ghislaine Maxwell, Virginia Giuffre, and Prince Andrew. And she describes them using a puppet, a caricature of Prince Andrew himself, and jokingly groping Giuffre with it.
Why is that incident forensically significant?
Because it places Prince Andrew and Virginia Giuffre in the same private space, in a casual, intimate setting on the timeline Giuffre alleged.
So it's not just Giuffre's word against his.
It's independent witness testimony. It's Sjoberg saying, I saw them there, and this specific strange thing happened. It corroborates their interaction.
Sjoberg also mentions other famous names in her deposition. David Copperfield comes up.
He does. Sjoberg mentions having dinner with David Copperfield at one of Epstein's properties. Now, we have to be very careful here.
Right. Being named in a deposition is not the same as being accused of a crime.
Exactly. Sjoberg places Copperfield at the location. She establishes his presence within that social circle, but she does not allege that Copperfield abused her or took part in any trafficking.
She only testifies to his presence.
She testifies to his presence. It's a critical distinction. We confirm the association, but we do not manufacture an allegation where the record doesn't support one.
Let's apply that same strict standard to the flight logs. We have these logs as a standalone document. The Clinton entries are frequently discussed. What do the logs actually show?
The logs are clear. Bill Clinton appears on the flight, manifests on multiple occasions. We have documented travel on the aircraft.
But the crucial constraint is the destination. What do the records show about where those flights went?
The public flight logs we have document trips to Africa, to Europe, domestic flights. What we do not have in these specific records is documentation placing Bill Clinton on the island, Little St. James.
So there's testimony alleging he was there, but the flight logs themselves don't show a landing on St. Thomas or a boat transfer for him.
That's correct. We must state it clearly. We have logs placing him on the plane. We do not have documentation from these logs of him on the island.
And the same rigor must apply to the Trump entries.
Yes. Donald Trump appears in the flight logs. He flew on the jet. The logs document travel, for example, between Palm Beach and New York.
People often confuse this with something called the list of 28 girls.
Right, and that's a mistake. We have to distinguish between an allegation in a list, which can be unverified hearsay, and sworn testimony in the Epstein criminal case.
So what's the status of the evidence regarding Trump?
Documented travel. The flight logs prove he used Epstein's transport, but the data regarding specific events during that travel is incomplete in the public record.
So just to be clear, documented travel for both, but we don't have documentation for specific criminal acts during that travel from the files we're reviewing.
That is the accurate forensic statement.
Okay, let's move to evidence block 4. This gets to the why. Why did this continue for so long? We're looking at institutional decision-making. Specifically, a letter from the Palm Beach police chief, Michael Ryder, to the state attorney, Barry Krischer. It's dated May 1st, 2006.
This letter is, for me, the smoking gun of the institutional failure. It reveals a huge conflict of jurisdiction, a conflict of will.
And Chief Ryder does not hold back.
No. I want to read the specific quote. He writes to the state attorney, "I continue to find your office's treatment of these cases highly unusual."
In bureaucratic language, highly unusual is practically a shout.
It's a scream. This document proves the internal friction. The Palm Beach police, they believed they had probable cause. They'd done the surveillance, the interviews. They were ready to prosecute at the state level.
And Ryder is documenting that the state attorney, Barry Krischer, is blocking it.
He's blocking it. And Ryder isn't just sending a complaint. He sends a package.
The filing package.
The letter says he is sending probable cause affidavits and case filing packages regarding Jeffrey Epstein, Sarah Kellen, and Haley Robson.
Let's pause on those last two names, Sarah Kellen and Haley Robson.
This is immensely significant. By May of 2006, law enforcement hadn't just identified Epstein. They had identified Kellen and Robson as key facilitators, as recruiters.
Which corroborates the victim testimonies about there being a network of recruiters.
Exactly. The police knew who they were. They had evidence to charge them.
So why weren't they charged?
And that's the accountability gap. The decision was made to federalize the case. We see this documented in the Department of Justice Office of Professional Responsibility report. The state attorney deferred to the feds.
And the feds then cut the non-prosecution agreement, the NPA.
The NPA, which covered potential co-conspirators.
So by sealing that deal, they effectively gave Kellen and Robson immunity.
That's the outcome. The Ryder letter proves the police wanted to prosecute them. The institutional decisions made at the state attorney and federal levels created this gap that allowed the recruiters to walk free. This is the exact gap Courtney Wild later sued over.
This leads us into our next block, the credibility battles. Not every document is a smoking gun. Some are complications. We have the unsealed documents from Giuffre Maxwell and the specific issue of Sarah Ransom.
Sarah Ransom is a complication, yes. We have to look at the legal proceedings, specifically an intervener's request for confidentiality modification.
And this involves the so-called ransom emails.
Yes. There are emails in the record, ransom 000000295 and others, where Ransom alleged she had video evidence. She specifically mentioned high-profile figures, including Clinton and Trump.
This is the source of a lot of speculation online. People hear video evidence and assume it's real.
But the court record shows the opposite, at least regarding the existence of the footage. In the legal filings, the other side argued that Ransom admitted to fabricating the existence of these videos. To draw attention to the case, she claimed she was bluffing about the videos to get the media to listen to shine a light on Epstein.
So we have to be extremely precise here.
We must state the gap clearly. The emails exist, we can read them, but the video evidence they describe has never been authenticated, never entered into the public record.
And was effectively retracted by the witness in subsequent proceedings.
Correct. It's a stark reminder of the difference between a claim made in an email and a verified record in a court case.
Speaking of credibility, let's go back to Ghislaine Maxwell's 2016 deposition. This document is a masterclass in the denial strategy.
It is. This is the civil deposition where she's under oath answering questions from Giuffre's lawyers.
And her strategy was just total obfuscation.
I don't recall. I don't know. I never saw that. She specifically denied recruiting anyone. She denied sending Giuffre to Prince Andrew.
And this deposition became her undoing. It was a trap.
It was the perjury trap. Because the flight logs, the Stoberg testimony, the photograph, all the things we've been discussing proved she was lying.
So those sworn denials in the 2016 civil case
laid the groundwork for the later criminal perjury charges. She was convicted in large part because her denials in this document were contradicted by an overwhelming amount of physical and testimonial evidence.
All right, let's synthesize this. We've looked at Giuffre, Wild, Joburg, the logs, the police files. What is the verified pattern that emerges?
When you combine all these sources, a clear, almost industrial pattern comes into focus. First, the targeting of minors. The age range is consistently 14 to 17.
Second, the non-sexual entry point. It always starts with the legitimate-seeming job, a spa assistant, a massage appointment.
Third is the escalation. The boundaries are eroded, the environment shifts, and sexual acts are introduced as a requirement.
And fourth, the pressure to recruit. The pyramid. Victims are coerced or incentivized to bring in the next victim.
And the corroboration matrix ties all of that together.
Oh, so?
The flight logs validate movement. The writer letter validates that police knew who the recruiters were. And the Stoberg deposition validates the environment inside the homes and specific high-profile interactions, like the one with Prince Andrew.
But we also have to be clear about the unproven.
Absolutely. We have to address the myth of the client list. There is no single document in the public record titled client list.
What we have are flight logs.
We have flight logs. They prove association. They prove travel. They do not, by themselves, prove participation in sexual acts for every single passenger.
So we have documentation for travel.
We do not have documentation for criminal acts by every passenger named. That is the line. That's the difference between this work and speculation.
So, to summarize, we have reviewed the sworn testimonies of Giuffre and Wild. We have cross-referenced them with flight logs and the Writer police files. The pattern of organized trafficking is documented. The institutional friction protecting Epstein in 2006 is documented.
The documents tell the story of a system that worked exactly as it was designed to. It worked until the sheer weight of the victim's persistence finally broke it open.
Here is a final provocative thought for you. The records show the Palm Beach police identified Sarah Callan and Haley Robson as targets in 2006. They had the affidavits ready to go. Why 2 decades later does the public record show no prosecution for these named recruiters?
That is the question the files leave unanswered.
Next time, Victim Testimonies Part 2.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.